Welcome everyone. We are here for the webinar on RGPD. I'm going to introduce this webinar by a small presentation on Digitalcity.brussels. So we had the innovation hub in terms of digital transformation in Brussels. We gather the key actors of the digital sector to help in the web transformation of Brussels region. We have private and public partnership in between Bruxelles Formation, VDAB, et Validation des Compétences for all training and skills validation. Digitalcity, which is in charge of all corporate matters, and Acteris, our employment partner. In key numbers, we have around 20 classrooms, 25 experts, and 60 training per year. We have a wide range of targets, job seekers, workers, companies, as teachers and students. Our operational services and functional departments are quite linked, from infrastructures, training, employment actions, skills validation, corporate watches, and publications. We have more than 3,775 square meters at disposal with top-notch equipments. And we have an auditorium, a creative room, facilities, training rooms that you can also rent if you're a corporate business. We are here today for a webinar on GDPR, which means that we are going to tackle what is this regulation for businesses, because we know that the implementation of the European Union's General Data Protection Regulation, so GDPR, was on May 25th, 2018. And it has evolved and increased in complexity since, and particularly with regard to remote working arrangements or global HR data systems. For businesses, GDPR has been seen as a positive development. It has accelerated data management and allowed new business models. However, we need to make employers and businesses aware of its impact and what the future hold in this area. For this, we are more than thrilled to welcome 4 experts today. So Saba, Parsa, lawyer and BPO certified at Alta Law, Nicolas, Roland, partner at Unity, Gregorio Matias, cybersecurity consultant at MCJ, and Laura Cerrato, information security advisor at CRB. Before we get into the nitty-gritty, just to give you a quick overview of the features you will need during this webinar. So on the right of your screen, in the side panel, you have 2 tabs, a chat tab and a question tab. The chat tab is only used to say hello, leave a comment, and the second one is only for questions. So please do use this one if you have any question. So I hope this is all clear, and I suggest to start this webinar right now. And I would like to give the floor to Saba, Parsa.
Hello, everyone. Thank you, Noemi, for that introduction. As Noemi told you, I'm actually, we can already change the first slides. I'm actually a lawyer, but I'm also DPO, and I'm also chief editor of the DPO News, which is a legal magazine about GDPR, helping actually not only lawyers but processor controllers in their compliance to the GDPR. Next slide, please. Yeah, Next again, yeah, thank you. Then today I'm going to introduce you a general context of the GDPR. I'm going to start with an historical context. Then we're going to see the main changes. And at the end, I will just approach some important number about GDPR and the way it's enforced in Belgium. We can change the slide, please. Then I just actually would like to have a little test with you, have a little, pool, if you don't mind. First of all, I thought I can do it with VoxVote, but the technical is not actually really, didn't allow me to do that with VoxVote. Then let you answer my question on the chat if you feel comfortable enough. I'm just wondering if you know how much what is the average cost of data on the market? Do you know? And I'm going to give you some proposition. Do you know how much cost a data, an average amount of data on a market? Is it like €1, €100, or €0.01? I'm not going to be specifying that question. Thank you, Luc. Here, I just want to have an average value. If you imagine the most expensive value, which could be, 25. I have 25 for Luc, yeah, 100 for Nicolas. Yeah, that is you're all right. That is the average value of a data. You have data which are more expensive than that, and we have data which is less expensive than that. That could explain why the GDPR needs to why actually we do need to be compliant to GDPR, because data has a big value. Could we change the slide, please? Thank you. But if we're talking today about GDPR, it's really important for me that you can understand that it's not kind of a revolution. Huh? The GDPR, it's more an evolution, and it's coming actually slowly to us. There was in Belgium already a regulation, a privacy law since 1992, which is completely not new, and there was already a directive which was applicable, which had been applied since 1995. Actually, the GDPR is going to introduce some new principle just to be able to protect, as it's supposed to be, the data. And today we can say that data protection, it's a human right. Then if you can change the slide just to be able together to see the how that transition was coming. You can change the slide. Yeah. Okay. What I would told you, it's the GDPR is actually an initial idea of the European Commission's observation that the then legislation, the directive, which came into force in 1995, needed to be updated to take into account the technological development. Then in 2022, Brussels therefore proposed a new regulation, and there was talking between Council, Parliament, and Commission. And on the 50 December, the project of GDPR was adopted. The text actually progresses at European level took place in a particular context. It's really important for you to know that we have two really important doctrine issued by the Court of Justice, which really lead us to the GDPR. The first of all, it's the well-known decision called Google versus Spain. In that in that famous decision, the Court of Justice actually obliges Google to satisfy internet users from the old continent, from Europe, who requested the removal of results concerning them. Thus, the court actually enshrining the existence of a right to differencing what we actually call today the right to be forgotten on the net. The second big decision, the decision of the 1st October 2015, the same court invalidated the so-called safe harbor. The safe harbor was the legal regime which allowed American companies to import personal data of European citizens into the US. That in that context, the GDPR, the enforcement of the GDPR and the new principle of GDPR seems to be really important. Then I talked to you before about why it is so important, and I want to share with you some numbers. Today, we really use lots of data. We're using in 2 days more data than we used before, and in a historical way, in the beginning of the history till 2003. Every 2 years, we double the global volume of data we actually process. And the data have a really important value. As Luc asked me, if you want to know, Luc, the data about the sex, it's exchanged on the market around €2.50. Medical data around €20. And if you want to say a password, you can sell it 70 euro on the black market for sure. Then the value is really important, and this is just some example. Can we change the slide, please? Thank you. This was the slide I want to talk to you about why. Then we also faced since the GDPR lots of historical scandal. I guess you know the scandal Cambridge Analytica. I guess you know the scandal Ashley Madison. And I want to share with you a video which have been made by Fibelfin. And I really will, I cannot share it now with you because of the technical issue, but I really invite you to look that video, because it's really important to know that the way you share your data could really play against you. And the way you share your data on social media particularly. Then let us change the slide, and going into the biggest changes which have been enforced by the GDPR. It's really important for you to understand that the purposes of the GDPR, the aim, is described in the provision 1 of the GDPR. There is two biggest aims. First of all, GDPR want to strengthen the right of individual with regard of the processing of their data, and they consider data protection as a human right, like every other human right. And the second aim is to ensure at the same time the free movement of personal data within the Europe territory. To be able to do it, the GDPR changed the approach we have of liability, of responsibility, and introduce the concept, the principle of accountability. Under that principle, you all should be able to prove at any time that you are compliant with the GDPR, with all the provision of the GDPR. To be able to prove it, the GDPR himself also provides some obligations. As the register, you had to keep a register of data processing as an obligation of transparency. You had to communicate properly about your processing, for instance, with the privacy policy. Then there is real obligation and general principle. I want just to introduce you to the general principle. If you can change the slides, please. The slide, please. Yeah. Then if we talk about those general principle, the first one is the lawfulness of the processing, which means that you couldn't anymore process any data without of having a legal ground, and all those legal grounds are described in a limited way into the GDPR provision 6 and 9 if you have sensitive data. All your processing had to be fair and done with in a transparent way. That's really important to communicate enough about your data processing, personal data processing. You also need to have a purpose. Every processing should have a purpose, and because of the data minimizations obligation should be strictly necessary to achieve that purposes. Your data should be accurate. Also, you need to limitate the storage, and last one but not least one, all your processing should be should have an adequate level of integrity and confidentiality. And because you're accountable, you at any time you should be able to prove that you actually follow those principles. Let me go further about with the next slide and talking about the GDPR, how it is enforced in Belgium. Next slide, please. Thank you. Let us talk about numbers again. As you can see, the enforcement of the GDPR during those last two years have really rise in a good way. As you can see, the APD, which is the Belgium APD of GBA, which is the Belgium Data Protection Authority, there have been lots of data breaches which have been notified, but this year we notified 31% more data breaches than last year, which means that people are more aware about what happens, what is a data breach. Then the Belgium Data Protection Authority also registered more complaints this year. As you can see, we have nearly 5 times more complaints than last year, and the public authority also requested more opinions, because we have 68% more opinions which have been issued by the Belgium Data Protection Authority. And we also have more DPO this year than last year's, which means, yeah, I think the Belgium the Belgians are more aware about the GDPR and the obligation which are compelled of under the GDPR's regulation. In 2001, we also have our first code of conduct, which is a European level code of conduct, and the first interim measure have been issued by the GDPR, and also the biggest fine have been issued in 2020. It was against Google, and again against the right to be forgotten. It was a really important decision, and really an important amendment. Then, if you can change the slide. What are the jurisdiction of the APD? What are your risks, actually? Then APD could actually really investigate to be sure that you are compliant to the GDPR. They can issue fines or other kind of sanction. And if you are public authorities, you can also be fined, because people think that's not the case, but you can be fined for every activity which is more commercial, because you also have commercial activities as public authority. You are not only on you're not only working on the general interest. And they also issue opinions helping people to be able to be compliant to the GDPR, just to enforce the GDPR in your own company. if they actually issued address actually a strategic plan for 2020 to 2025, and they aim to protect the citizen, and also they also want to participate to the change of philosophy which is induced by the GDPR. And then they will communicate with you, giving tools to people. Can we change the slides? Thank you. Yeah, and they will give you tools and other advice, and they will be concentrated in some specific area or field or sector. They will be more concentrated for that period on public authorities, helping them to improve their compliancy, but also for small and medium enterprise. They also would help some specific area like marketing direct, but also using of camera and pictures, which was really important during the COVID period we've been through. And they also give tools. If you can change the slide? Yeah. And those tools are about, yeah, thank you. They provide you register. There is a new version of their register for controller. There is also going to provide you register as processor for the register of the processing of your data. They also give guidance. There is one of the biggest one is about the direct marketing. There is also Project Boost, which can help the small and medium enterprise. With the Project Boost, they will give new tool, they would give new advice, they would give you checklist and other stuff just to be able to find your role in the processing you are doing, and also helping you find your to realize your obligation. And the GDPR also the GDPR, the APD also started a new project called DPO Connect. That project it's realized in association with the DPO Pro Association of DPOs, helping them to actually enforce the GDPR in their own company, helping the DPO to enforce GDPR in their own company. Then yeah, it's actually, they already signed it. Nicolas asked me when it's going to be launched. They actually signed the agreement, and they will be started really soon. But they started with a consultation, and we are going to have the result of the consultation really in the next week. Then next slide. If I'm not sure, I'm at the end. Yeah, then thank you for listening. I hope that introduction helps you. And Nicolas Roland going to follow me to explain you in a more concrete way the impact of the GDPR. Thank you.
Yes, I'm sorry. Okay. Thank you, Saba. Yes, in a more concrete way, it depends. Actually, it will be focused on the international data transfers. So this is, I will discuss with you right now, and to give you some flavor, 3 topics. What's an international data transfer? What are the mechanisms that can be used in order to comply with the GDPR requirements in this regard? And last but not least, what about America? And as you mentioned earlier, Saba, the Safe Harbor and Privacy Shield saga. Let's have a quick talk about it. And first things first, it's important to understand that within Europe, I mean the European Economic Area, there is a free way to transfer personal data. So there is no further requirements, but this is within the EEA. When you transfer data outside the EEAA, you will have to look through different ways of working, and we will discuss it at a later stage. But it's important to realize that you may have more international data transfers, meaning outside the European Union, than you are maybe aware of. And it's important, as you will discuss it later, that you go through an inventory of all these international data transfers, whether you act as a data controller. I mean by that you are the person, the entity who will set the purposes and the means for a processing activity, or whether you act as a processor, a data processor, meaning that you will process personal data on behalf of a data controller. So, and in both cases, you have to ensure that international data transfer are done in a proper way. But what are we calling international data transfers? It's maybe even broader than you think. It's any communication of personal data from a data exporter to a data importer located outside the EU, or to international organizations. It's about the United Nations or the NATO. And so we are not talking about private organizations, but rather the public organizations. So in that case, so when there is a communication of personal data to international organizations, or to private organizations or public authorities outside the European Union, we are talking about international data transfers in the sense of the GDPR. We are more precisely talking about third countries. As I mentioned earlier, it's quite broad, not only a file sent via Outlook. It's also when you have remote access to data centers located in Belgium, for instance, from a person located in the US. So in that case, there is an international data transfer, and you have to consider how to tackle, how to cope with the requirements of the GDPR. And in that case, you have a layered approach, meaning that you have to satisfy the requirements, and you have first to identify the third country at stake. And the European Commission has found for some of third countries that they have in place at home in their own internal legislation sufficient mechanism in order to ensure the protection of personal data that have been transferred to these locations. And there is a list published on the website of the European Commission with the eligible countries satisfying the adequate level of protection of personal data. And you may find some of them listed on the slide, such as Argentina and lately Japan. So actually there are around 10 countries offering such an adequate level of protection in their own legislation. So when you transfer data to these countries, you don't have to put in place additional requirements. But of course, there are other countries, other third countries, and in that case, as I mentioned, there are different mechanisms to consider. And the most well-known mechanism is the standard contractual clauses. These are provisions established and published by the European Commission. You cannot deviate, you cannot modify the standard provisions. It's not allowed. You just have to fill in the concrete details of the international data transfer at stake, meaning the categories of personal data, the categories of data subjects who are concerned by this processing activity. And you have to ensure that the data importer and the data exporter execute these standard contractual clauses. We will see at a later stage that these standard contractual clauses have been recently questioned by the European Court of Justice. And I can already tell you that as a result thereof, there have been new standard contractual clauses, so new versions that have been published last Friday. So it's fresh news, I would say. And this new version of the standard contractual clauses address, allegedly, the concerns raised by the European Court of Justice. So now it should be easier to use the new version of the standard contractual clauses without the fear that the European Court of Justice would dispute the mechanism that has been put in place, and so with a lot of situations where the data exporter is a controller, either a controller or data processor, and the data importer is either a controller or a processor, which was not the case in the previous version of the standard contractual clauses. So this is a mechanism that is endorsed by many organizations, because it's a simple way of transferring personal data abroad. But this is not the sole mechanism. As you can read on the slide, you also have binding corporate rules. It's, to put it in a nutshell, it's a set of rules within an organization allowing data transfers within the international organizations and the several locations around the world. And these binding corporate rules must be approved beforehand by a data protection authority, a European data protection authority. You also have certification, code of conduct. It's less frequent. So as I said, the standard contractual clauses are really used more often than other mechanisms. And if you have, in some circumstances, occasional international data transfers, you may also rely on other mechanisms, such as the explicit consent of the data subject, or compelling legitimate interests, and that is further elaborated in the guidance provided by what is called the European Data Protection Board. The European Data Protection Board is the entity providing advice on a European level to the on this matter. We have representatives of the different European data protection authorities, and they discuss the guidance, and related recommendation as regards the GDPR, such as, for instance, the international data transfers and the specific situations where occasional data transfers are allowed. And if you don't satisfy these requirements, then you are not allowed to transfer personal data abroad, and you might be fined by the data protection authority, or even by a court. And as Saba mentioned earlier, fines can be huge, depending on the case, depending on the amount of data transferred, and so on. So you really have to ensure that when you transfer personal data outside the EU, you have a proper mechanism in place, and that you have documented this mechanism when you rely, for instance, on a derogation in specific situations, because this is part of the accountability principle that Saba mentioned earlier. So you have to demonstrate that you are compliant with the GDPR requirements, at least in this regard. And in one particular case, it's very important to look at how in practice this could be impact your activities, because we almost all of us rely on services provided by American companies, organizations, on a personal aspect, or for professional transfers. And you have to ensure that when you entrust data to US companies, that the subsequent or the related international data transfers are done in a proper way. And otherwise, you might face injunctions or fines from data protection authorities, such as a company that used MailChimp. MailChimp is a well-known email services for newsletters and so on. And a German company has received a cease and desist order to stop using MailChimp, because there was no sufficient safeguards provided by MailChimp, even when the German company relied on the standard contractual clauses. And it was quite recent, I think 2 or 3 months ago. And now, as I mentioned a few minutes ago, based on the new version of the standard contractual clauses, the German company could retransfer personal data to MailChimp, provided that they fulfill all the conditions set out in the new version of the standard contractual clauses. So, and another mechanism specific to the transfer to the United States was the famous safe harbor and privacy shield. It was another mechanism in order to ensure that for the European Commission there were sufficient or appropriate safeguards when the data importers processed personal data from European companies, and actually, in the opinion of the European Court of Justice, this was not satisfactory. And based on the complaints filed by, I don't know if you know this guy, Max Schrems, who filed some lawsuits in Ireland, and then before the European Court of Justice, and the European Court of Justice found that this mechanism, the safe harbor and the privacy shield, that were less formalistic than the standard contractual clauses, were not adequate. And so the European authorities and the US government are currently discussing a new mechanism that will address all the concerns raised by the European Court of Justice. So in the meantime, yes?
Yes, Nicolas, I'm really sorry, but I will need to give the floor to Grégorio. Sure. We're really running out of time at the moment.
Sure.
So thank you, Nicolas. And I will give the floor to Gregorio Matias. I think, Gregorio, you're still muted. And you have to share your screen so we can see your presentation. Okay. I don't know if Gregorio is hearing us. Otherwise, I will give the floor to Laura if you are ready. And in the meantime, it will give some time to Gregorio to prepare.
If you can launch the slides.
Yes.
So
Thank you.
Morning. No problem. I was expecting to end the session, but now I'm not ending it. So good morning, everyone. So my name is Laura Cerrato, and I work for the BRIC. So in French, it's CRBG, CRB and CRBG in Dutch. So we are the IT arm, as I call it, of the Brussels region. Alors, when I was approached with the possibility to do a presentation regarding the successes in terms of GDPR implementation, I had to ask to change the angle of answering that question, because through my career, which is young in terms of GDPR matters, I cannot answer positively to the question. So I will lead you through my experience and how I tackle it, knowing that the ending is not, I would say, so bright than I would expect it. So voilà. First of all, like this. First of all, who I am. I'm a DPO ISA, so Data Protection Officer and Information Security Advisor for 11 public entities in the region of Brussels. We deliver DPO and information security as a service for 34 public institutions, and for each public institution we deliver around 5 to 25 days of work, which is not much when you are confronted with this huge program of compliance. My background is not legal. I'm an IT person. I've worked first of all as web developer, and then afterwards I was an ICT coordinator. The biggest part of my career was in the private sector, and since 2 years now, I've discovered, and I'm still discovering, the public sector. Oh, no, it's the other button. Let's start with a simple joke. The figure that is presented here shows what I am confronted on a daily basis when we discuss privacy matters. If I have to take back the objective set by the Belgian Supervisory Authority, where the public sector should be leading by example, I can't say that we are meeting that objective. It's quite complex to understand why it is. I've listed several ideas. Some of them are from my experience, others are from contextual elements. First of all, the public sector suffers of a Gollum attitude, meaning that the data, it's theirs. They will not give it away. They want to keep it for historical purposes, and this is part of their DNA. So it's quite a bit difficult to confront that with the principles of the GDPR, one of them being minimization of data. And so there's a clash. Afterwards, there's also the attitude towards the law itself. I don't know why, but they think that the GDPR and other privacy laws, because it's not only GDPR, we have the e-privacy directive also, it's only targeting the private sector. But it's not the case. It's also impacting the public sector. And with that, you have the complexity of the digital transformation that goes in confrontation with the old-fashioned ways of working, in the house, because we still have paper management, and they think that GDPR it's only technological oriented, which is not the case. We are discussing data and their finalities and the way we process them, being technological or manual. And this is not correctly understood. Then also, and this maybe is for the moment the I would say the added value, or not the added value, but the fact that they are in a positive environment is that because the citizen still has trust in their public sector. Bon, I could say it's a breaking down when you see the different press articles regarding data at the center, the way that we are handling data in the COVID session. And I can even make a link, if I want to take a huge example, is the fact that people went down to the Capitol because they distrust their government. And so this can be used against even public sector if you do not do properly the compliancy framework set by the privacy laws. I also heard through different clients, because I work with communes, CPAS, and OIPs, that, yeah, that's not a problem. Even if it is a breach, nobody will die. And I have to go back to a case that happened in Berlin, I think 1 year, 6 months ago, where a hospital was hacked and a patient died. And this is going to go further and further because hacking went up to 200% since 2 years, since the COVID period. So these things have to be taken into account by the public sector, and it's difficult. And then higher up, there's the national security imperatives. And I can also add the specific legal system that we have in Belgium regarding privacy matters. As you know, the public sector is not fined if it's doing an illegal data processing. Yes, there are other kinds of fine that you have to go to the penal court, but the administrative one, the one that we discussed regarding private sector, up to 20 million euros and so on, is not applicable to the public sector. So it creates sort of permissive situation where, like a donkey and a carrot, the controller, the public authority controller, is not pushed to go further in the compliancy program. But do not lose hope. There are ways to tackle the issue. And my way of working, well, if I don't have the buy-in of the management, then I try to find the crack, not being an hacker myself, but I try to find the crack to get into a discussion regarding compliancy with people that are ready to change. Because it's a mentality, as one of my the previous speakers said, it's a change of mentality. It's a reasonable one, but it's confronted to the way that the old-fashioned way of thinking of public institution. When I approach the question towards managers, operational colleagues, and so on, I always try to be pragmatical. I always translate the law in terms of pragmatic action so that they can see how they can perform compliancy and how they can have benefits from it. Secondly, which is one of the most important because not a lot of people understand fundamentally what the laws provides as provisions, is to build and maintain an awareness program, an ongoing one. And this is fundamental because, as I said, some people have the idea that it's only private sector oriented and so on. You have to change that, and only awareness. I'm a huge fan of education, of course. I think everyone is, but it's really, really important to elevate people to knowing about the text and its intricacies. And thirdly is to find key contacts within the organization. Because let's face it, when you're a single DPO, you cannot manage the entire program. Yes, you will tackle the materialization that are set in the text to prove the accountability of the controller. But for the rest, it's an ongoing process. Once you've done your materialization, it doesn't mean it's ending. You have to go further. And those key contacts will help you to advocate your message and to change the mentality again regarding privacy management. So how I do it, and these are certain examples that I've produced and concretized throughout my work, is, for example, in one of my organization, I use the tools, communication tools that I've set in place, like, for example, Yammer, and I do on a 2 weekly basis a question answer news. I provide, of course, trainings, dedicated trainings, general trainings. I even am currently developing a video system in order to provide in both languages videos regarding specific topics of an activity within the organization. It's a long process, huh? I must say. I'm not finished yet, but voilà. I always produce also cookbooks that can be published and communicate throughout the organization, like, for example, regarding the trackers, regarding how to set up a form in compliant to GDPR, and so on and so on. And thirdly, and this is where I have some difficulties, I must be honest, is to set controls based on the privacy by design principle when you purchase a service or a tool that will handle data or within a project. Sometimes it's okay, sometimes it's not okay. I have one organization who has set those controls. It's not working perfectly, but voila, there's a change, there's a move towards compliancy. No, now the perspective, I must say, for the public sector is not great. Things are going to get more and more complex. And the public sector should integrate that legal design within their strategy. They have to bear in mind that there are new laws, revised laws that are going to come up. The e-privacy is still the directive, but soon to be a regulation. There are new provisions in it that have to be taken into account. The artificial intelligence regulation is also setting new processings and ways of doing the work towards the data you collect through those kind of activities. There's also the Data Act that's already announcing a set of rules that have to be taken into account. And lastly, the standard contractual clauses, there is true, they are revised, but you do not have to take them as it is. You have to work them. There's a TIA, which has to be done by the controller as processor. I'm going to use those terms, but it's true, this data importer, data exporter. It has to be performed. It's burdensome. It costs money. There's also a small line that states that the data subjects can attack either the controller or the sub-processor to get retribution. And so those things have to be taken into account. So I'm saying it's really complex, and it's now that you have to analyze them and see how you can integrate or explain them why you are not putting them in place. That's the most important thing in terms of accountability. So voila, but do not lose faith. I'm not losing faith. I'm still pursuing my career as a DPO, because it's interesting. It's always evolving. New projects are coming on the table. It's true that sometimes you are not helped, especially the public authorities, when you see the legal framework around the missions that they are handling by law. It's true, laws are not really specific regarding the data they are collecting. There's a case in Holland where a city has been fined with a 600,000 euros fine because it was collecting data through the mobile devices of users going through a specific area in the and they were basing the data processing on laws and legitimate interest. Legitimate interest is not applicable in the public sector generally. The laws that they were referencing to were not sufficient because not sufficiently predictive and transparent for a citizen. And so the national supervisory decided that it was not legal because the laws were not sufficient. So it's really, really complex. And these have to be tackled before starting your processing. So voila, it's exciting, but voila, you have to go through it. Thank you very much.
Thank you, Laura, for this. That is really interesting. And I will give the floor now to Gregorio.
Do you hear me?
Yes, we do.
Wonderful. Sorry.
It's okay. It's okay.
Thank you,
happens.
Laura, to have taken the place because I get an issue with my microphone. So what I would like to do is to share just my screen, if I can, just a moment. And I will share my presentation. And let's go on with this one. Tell me if you see my screen. It's okay for you? Yes. So thank you, everybody. And the idea of my presentation is just to share with you the lessons learned from, I would say, the path to compliancy of some of our customers and organization, what we have seen, I would say, since the beginning. And well, we are not specialized in GDPR. Indeed, we are a company specialized in cybersecurity. We perform audits and we implement solutions. And sometimes we get a call asking us, well, we have an incident or data breach. Please help us. So this arrives again yesterday evening. But anyway, the idea is to share our experience from our perspective, and I would like to share it in three ways. The first is to come back a little bit on the GDPR timeline. Well, we get in the first presentation a timeline much more legal, but I would like to present it in another way from the, I would say, the organization perspective when they've seen the GDPR regulation coming up and the reaction. The second was, what was the starting point? And what was at that time, at the beginning of the GDPR, the situation of the organizations, and what kind of difficulties they have crossed starting the process of compliancy. And the third one is just to say, well, what is the link with this, the GDPR compliancy and today what we call IT security or continuous improvement in IT security? So let's start with the timeline. Where there is a timeline here I found on the internet. More or less, what we can see is that, well, the GDPR is just a certain point in time in the regulation of the, I would say, the processing of data, of personal data. But what was important is that in 2015, by the end of 2015, we know nearly everything about what will be inside the GDPR text that was published in 2016. And this is quite important because just imagine that the maturity date, the compliancy date has been put in May 2018. So we know more than 2 years before that all the organizations should be compliant to this regulation. And so the question is that, coming back to the organization and this timeline, what has been the reactions to this compliancy timeline? And let's go on a little bit on end of 2015. So remember, we know nearly everything about what will be inside. And the second point was January 2018. And between these two, so we get 2 years, 2 full years. What happens? Well, we have seen people just starting to discover very early the content of the regulation. And I remember that I was a speaker on a conference at the end of December 2015, and we get around between 17 and 80% in the room at that time. And people just wondering what's happening. What is this kind of regulation that is coming up? Is it compulsory? What should we do? What is the scope? And so on. So early discovery organizations were there present. And for sure, along 2016 and 2017, we get a lot of conferences about GDPR. The more we go to the maturity date, the more conference and information you get on the newspapers and I would say on the medias. And then in the second phase, what we have seen is that the early discovery organization just start to make the adoptions and started the compliance path. But some others has just started to understand what is GDPR, even at the end of 2017. So 5 months before the maturity date. And so between these 5 months, what happens? Well, we have seen a lot of stuff moving. First, the early adopters, I would say, are just in the compliance phase and maybe nearly finished. For others, they are just starting to understand, well, what is GDPR? And for the people that have just started before January to understand the GDPR, they just came to adopt the GDPR. And finally, what happens after? Well, it's a moving average for all the organization. And what's happened is that for some others, we have final compliance phase, and for others, they are just starting to understand. I remember a meeting with a prospect in somewhere in June 2018, and the question coming to me was, could you please explain me GDPR, because we are just starting to understand. So finally, where we are today. We have shared a lot of information in the previous presentations, is that we get some fine penalties, issues coming out, notifications about data breaches coming to the authority. But we have also, for the organization perspective, a maintenance phase. Why a maintenance phase? Because your business is moving, your data is living. So everything is changing. So you need to maintain the compliancy, otherwise you are not compliant anymore. So this is for the timeline. Well, from the compliancy path, I would like just to remember very simple stuff, you know it, but it's important to come back to the basics. GDPR is about personal data. And when the GDPR regulation comes out, well, when you have a look on the organizations, public or private one, you get two kinds of organizations. The first type is an organization that has just started and have a data classification. So the maturity of security, IT security is very high. So data classification looks like something like that. This is just an example. So they get public data, they can put outside and everybody can see it, internal data, confidential, restricted, someone, secret data. This is data classification. But nowhere in this classification, at some exceptions, we are not seeing personal data type. And this is for the most mature organizations. If we go to the less mature, they have no data classification. So just imagine right now that you have no data classification, but you would like to go to the GDPR compliancy, then you have an issue. So what's happened? For the organization, 3 basic questions were just coming out. The first one is that what type of data are we storing? Are we processing? Are we storing? The second, where is the data stored? Locally, on-premise, on the cloud, somewhere in another country? Where is it? And the third one, why are we processing this data? Why are we storing this file? Why have we this Excel file with a lot of personal information from prospects? Are we still using it? Yes or not? And so for organization, this was the starting point when they would like to go to the compliancy. And just imagine if you have an organization without any data classification, without no security policy, which is the majority of the organizations today, certainly the SMEs, the job and the huge work and the huge load you should cross to just start for the compliancy path. And so let's come back to this kind of compliancy to GDPR. So I'm not a legal guy, not at all. But what is important is what is inside the GDPR. What is the philosophy? What is inside what the regulator would like inside all the legal form? And you can sum up GDPR in a very easy way. The idea is to adopt IT security methodology and best practices in the scope of only one type of data, which is called personal data. And this is quite important. And you can see inside the GDPR regulation a lot of stuff linked to that. And one of them is the data protection impact assessment. What does it mean? It's nothing else than a risk assessment. This is well known in IT security policies. I remember that in 2017, I have been asked to make to perform a training for DPOs. And these DPOs had just arrived at the end, and these DPOs has just a lot of trainings about legal, GDPR, content, blah, blah, blah. And the idea is that I just come at the end and say, okay, guys, I have to explain you what means security. And I should make the, I was cross-reference from IT security to GDPR. And I started the course without mentioning GDPR term. After 1 hour, one guy just raised up the hand and say, sorry, but you should make the relation with GDPR about cybersecurity and blah, blah, blah. And I said, yes, just wait. At a certain point of time, after 2 hours, everybody look at me and say, what you're explaining is what is inside GDPR, but you are not using personal data as a type of data. And this is totally true. So if we come back to the GDPR compliancy path, what I've seen is that there are 3 paths. The first one, organizations that just want to be compliant, legally compliant. What does it mean? This is a minimal, I would say, effort, because they would like to go to compliancy. I mean, minimal, maybe it's quite huge because the starting point is very low, but at least we would like to make the minimal effort. And this is kind of opportunist. I would like to be compliant and it's fair enough and it's finished. The second path was a little bit more ambitious. They would like to go to the compliancy, but go also to the global IT security policy, and they would like to take all the company, all the organization, and change completely the culture. And just imagine that this is not the same as the first path, because here it's quite challenging, changing completely the culture inside the company about, I would say, global IT security, including for personal data. It's a quite extensive work. And we have seen organizations that just taken this second path. And then what we can see today, because when you take a path, at a certain point you arrive, I would say, to deliver something. So compliancy was the first objective, and for the second path, a second objective, much more bigger. But what we have today is that for companies that have just make an opportunist approach, we see that the maturity level in cybersecurity is very low. And for maintaining their compliancy, they have big issues because the challenge is there, because the maturity level is quite low. For the others, what we can see is that their maturity level has just increased drastically. And the maintenance of the compliancy is just a normal process, as for the other matters in global IT security. Well, but there is a third path. Where is this third path? And I just maybe, I would say, go in the same way as Laura has said, but in other words, for other type of organization, there is nothing. There is nothing. There is nothing. What means nothing? Very easily. They just purchased cybersecurity insurance. And complaincy, we will see if there is a data breach afterwards. And that's finished. And trust me, they have nothing. So maybe just finalize with something. GDPR is a big change. And remember that Charles Darwin just said the following, is that the most responsive to change, the species that are the most responsive will just survive. Thanks a lot.
Thank you, Grégorio. That was a good way to end this webinar. And I also thank Nicolas, that has been our quite a good moderator and answering questions. So I hope that everyone could find the answer they needed. Thank you, everyone, for sharing your thoughts and insights on this subject that we could tackle quite endlessly at the moment. And I wish you, everyone, a very lovely day.
Thank you. See you.
Thank you.
Thank you very much. Have a nice day. Bye-bye.
Bye-bye.
Have a nice day.